I wanted to turn to another point, which is the unpleasant consideration of life events and how they will affect the plan and plan compliance. The way I remember the life events that can affect a Rob's plan are by calling them the 4 Ds, and those are death, disability, divorce, and disputes.
I think as far as disputes go, we'll start. I know that was the last one you mentioned. I think divorce and disputes are probably the two
Yeah.
that I have most exposure to that end up on my desk. I think the primary strategy is just making sure that you're discussing these things prior to having an event.
Right. Yeah.
Talking about it in advance and really documenting kind of what is your strategy going to be. Having something that you can refer to and say, we talked about if this was going to happen, we have a protocol that we're going to follow that's going to help us solve this. I know that
Oh,
that's not always practical, but that would be ideal.
excellent. And so to throw in my attorney's recommendation for such a document, in the case of the co-owners, that would be who are not married to one another, that would be a shareholder agreement. A corporate attorney can help you draft a shareholder agreement in your jurisdiction that will help you and your co-owners navigate issues before they impact the company's value. I'm going to give an example of something I've run across where franchise owners were two married couples started a yoga studio. One couple decided after about 18 months that they didn't like it. They didn't enjoy working in this context. One couple had to bow out, but there was no shareholder agreement. And I was involved in an advisory capacity for the plan, which I didn't have to take sides in the dispute, but there ended up being a dispute about valuation of the company. Just, it wasn't a huge issue, but it took a while to figure out, and it was expensive because they each had to lawyer up on each side. Each couple had their own corporate attorney advocating for their position after the fact, after the dispute arose, which was how much does this couple get out of the company for leaving? That's, they wanted to leave. What is their stock worth? They hadn't thought to hire one corporate attorney at the beginning to write out a fair and square shareholder agreement about navigating such a dispute in the event such a thing arose. And a shareholder agreement can address all kinds of contingencies that are reasonably foreseeable and that are common. And corporate attorneys are familiar with these kinds of things and can help you draft something. You don't have to adopt a shareholder agreement before the corporation is formed. You can do it now if you're a Rob's owner with several partners.
That's so when you were
Divorce.
describing the dispute over valuation, that was the first
Yeah.
thing that I actually thought of because that's usually, if there is a point of contention, I've seen it be surrounding, okay, we have these non-publicly traded shares. We can't just Google what is this share worth today. I tell clients all the time, hey, you could go to 3 different valuation companies and they're going to give you 3 different numbers. And none of
Mhm.
them are maybe wrong. It's just a matter of, looking at the approach. So I think
Yeah.
that as far as divorce goes, if that's something that's, part of a conversation that's happening in your life, again, talking to your third party administrator and helping them understand the things that you need to know that may be able to help the conversation from getting too far down the line without somebody understanding the unique kind of parameters that you're going to have to navigate with the business because of your funding strategy. So again, what the first thing I always say is, make sure that they know that the retirement plan is a shareholder, because a lot of times they'll just go, well, I'm the only shareholder. Well,
Yeah.
I know what they mean, but they have to say it exactly, the technical way, which is the retirement plan is involved. So if we start talking about there's only one participant, but the husband, wife have always made decisions together, and that was their intention.
Right.
Understanding if the business is going to be split in some capacity, you're splitting it from inside the retirement plan. And a lot of times that's not necessarily what happens, but just having that fact out there. And then also, I
Right.
always, in that kind of conversation where we go, okay, what do I need to know? Just understanding that if retirement plan assets become a part of the assets that are being split, that is done with a court order that is not the divorce decree. There's a qualified domestic relations order. It's a specific type of court order that is used specifically
Yes.
to change the taxpayer associated with the retirement plan assets. So there's reasons and motivations as to why you may want to try to avoid the a quadro is the acronym we
Yes.
use. And then there's other times where it makes a lot of sense, and you're going to want to work with your third party administrator to make sure that that court order is approved. All the language is exactly the way they need it, because I've had clients going through a divorce. They send me a quadro that is already signed by the judge, and it
That's not
doesn't meet all the
appropriate.
parameters for me to be able
Yeah.
to process that transaction. So then it's more attorney fee. They have to go back in front of the judge. Who knows
Mhm.
how long that's going to take to get signed.
Right.
So I always ask to get a proof before it goes to the judge, just to kind of get that last check of, yes, this language has been approved. There's nothing
Yes.
that's left up to interpretation that we would be concerned about.
The TPA is as the outside administrator of the plan assisting you, Rob's owner, has a legal duty to handle plan assets very carefully in accordance with the terms of the plan document and in accordance with all of the applicable rules. So if the quadro, that's the qualified domestic relations order, if the quadro is not written just so, as Holly said, the TPA will not have the legal authority to implement it. So it needs to be drafted properly before the judge signs it. The other point I wanted to make about the disputes, death, disability, and divorce is that when there's a surviving co-owner, after or the company is expected to continue after one of these life events, one thing that you should just be prepared to consider is that the value of the company may be impacted financially by the loss of that key person who is now out of the picture. So in the case of a divorce, if a spouse has been helping her, let's say the wife is not the Rob's owner, the husband's a Rob's owner. The husband is the one who has legal title to the assets. He's inside his plan account, but the wife has been working hard to help the company succeed. If they break up, the wife is no longer adding that value to the company, and that can have an impact on the company's revenues and prospects and value. So not only the actual legal mechanics of breaking up with the plan account, that's what we've been talking about so far, but also the value can be affected by the loss of that key person who may not have been employed but has been actually helping the company succeed. This happens with co-owners who are not married, such as friends who start their company together, and then they have a dispute. One of them's out of the picture, and they're no longer. They might, long before the legal effect occurs, the person may not really be working hard to make the company successful. That can actually depress the value of the company. That's why a shareholder agreement has some money attached to it. You're anticipating, you're creating a shareholder agreement with the idea of preserving value for the company in such an event as a dispute, for example, or a divorce. This is very, very sad. I've come across this many, many times as an ERISA attorney advising Rob's plans, and that is that the widow of a Rob's owner who has died, where there's a successor owner as well, co-investor that has not died. There's a surviving co-owner and the widow or widower. That widow or widower is probably more interested in getting some money out of the company than they are in helping the company continue to succeed. And so the death beneficiary, the widow or widower, becomes the Rob's co-owner of their decedent spouse's shares instantaneously upon the death of their spouse. This doesn't have to go through probate. This has nothing formal other than the death of the Rob's owner instantly creates a new Rob's owner who is the death beneficiary under the terms of the plan. In most states, by default, that's the spouse, if there is a spouse, or it could be however the state law works to create a death beneficiary if the person hasn't named a death beneficiary. But whoever that person is, they become the Rob's co-owner with that surviving Rob's owner. And the surviving Rob's owner may have no desire to have a co-director in the company that they don't know, who has no interest or skill or desire for the company to succeed. They simply have assumed this role because of the death of their loved one. And then keeping in mind that both parties are probably grieving the loss of their their co-owner, partner, and spouse. So you've got two very emotionally, people who are in emotional crisis, grieving the loss of a key person, and they're going to find out that the value of the company is severely impacted by the loss of that key person. So the solution for death, to prepare in advance, is for the company to buy key person life insurance. This is a life insurance policy on the life of the co-owners, and the company pays the premium and is the beneficiary of the premium. That pot of money can be used to buy out a widow or widower so that they are no longer associated with the company, or it can be used to hire a person to pay for the salary of a new person who has to be brought in to sustain the value of the company by replacing that key person who has been lost. I think it's worth considering, as unpleasant as it is.
I have had personal experience with people who have had some sort of key life insurance policy in place. And I have personally witnessed that it does make things a little bit more smooth, and it helps kind of make sure that the company has a little bit, it can absorb maybe a little bit more while it's going through a transition. But I will just add, for all of the listeners, one thing that everybody should write down and go do immediately as it relates to this is make sure your TPA has an updated beneficiary designation form and it's signed. And I think in addition to that, making sure that your beneficiary knows that they are the beneficiary. Like I said, a lot of times when you're going through these hundreds of pages of documents when it comes to adopting a retirement plan, that's one of the things you have to complete. But you would be surprised how many times that doesn't get sent to the TPA. Something happens and we look and it's like, okay, it's either here if they completed it, and then we have to operate without, and that's never easy. So go call your TPA, ask them if they have it. If they don't, get it from them, complete it.
I have to check myself, because I don't know. I don't recall filling one out in May when I adopted my plan, and I have to go find out. Thank you for that tip, Holly. I will be doing that. If there's more than one Rob's participant or more than one investor family in the company, say there's 3 or 4 people involved in a company and they're married, if one of those people dies, and suddenly, especially if it's suddenly, the stock of if they're a Rob's owner, their stock automatically becomes moved over into the ownership or beneficial ownership of their death beneficiary under the terms of the plan. Sure. So now you've got your 3 surviving stock owners and the decedent stock owner's beneficiary, who is now a voting member of the corporation through their beneficial ownership of their deceased spouse's shares. In addition to the emotional context that everybody's probably grieving the loss of this person, that's not something that's no small thing. But legally, this is what's happened: is this person has stepped into the shoes of their deceased spouse's member ownership or control over this corporation. And so that kind of situation it can be dealt with if it's anticipated in advance of the death, for example. There are ways of dealing with that. This is particularly relevant to anybody who's watching this, who's a subscriber to robsresource.com. There's an entire thread on the website that is called Life Events, and it's discussing just this sort of thing.
Why do we create these documents? And yeah, record keeping is important. We have agencies that need to be, looking at this, but primarily these are internal documents. These are really for the benefit of the corporation. You generally don't share them with anybody unless they're asking. Maybe your bank will ask for internal documents when you apply for a loan. If you're being audited, or if there's some problem with your plan, then this stuff comes to light. But primarily, you're creating documents just for the benefit of the corporation itself. Meaning,
Right.
you create a resolution or you create bylaws and no one ever sees them except for you. And I think that changes when you involve other owners, right? Because when it's just
Yes.
you operating a business, you're really doing it as a formality. But when you have other owners involved, there actually is a lot of reasons why these documents exist, and they start to perform functions that are not just record keeping.
Okay.
And you mentioned the different types of owners that there could be. I have lots of clients that are married and their business partner is their spouse. In
Mm-hmm.
those instances, I would say these internal corporate documents, they're really not important because your marriage certificate supersedes anything that we do on the business side, right? And
Right.
the
Yes.
reality is, if you can't make decisions as a couple, like the business documents are not going to protect you from that,
Right. Right.
But
Yeah.
there's a lot of other relationships that I think do benefit from these corporate documents. Brothers and sisters going into business, any type of family member that aren't spouses, even parent and child relationships, lineal
Mhm.
family relationships, and then especially third parties, people that you're not related to, your
Yeah.
friends, colleagues. If you're going into business with these people, I do think that these internal corporate documents start to serve a very good function, which is we, as two separate entities, two separate people, have different views and agendas, different
Yes.
goals. Our business generally will have a single goal, it's to make money. And
Right.
um, modern entities like LLCs have done a great job of turning the corporate documents into something that serves the owners. And they have a document called an operating agreement. And these have become such a silver bullet for solving a lot of these business problems that now, if you go into a bank and you tell them you have a C corporation, they're still going to ask you for an operating agreement.
Oh,
But
even though
corporations don't do that.
yes, right.
So what do you do in those cases? Because they really want to see an operating agreement. The corporate equivalent of that is a shareholder agreement. And it
Oh,
can do pretty much everything that an operating agreement does, which is talk about, okay, what happens when the business needs money? What happens when the business makes money? Who's it going to and in what percentage? What happens when major decisions have to be made? How do we make those? And
right.
then specifically the examples you gave, which is what happens in the event of succession, because yes, we acknowledge that ownership is going to pass through, trusts. How
Mhm.
does that relate to the operations of the business? And this is something that usually doesn't get thought of a lot of times in succession is we know that the ownership has to pass to the spouse or whoever, you want your ownership to pass to, but should they
Yeah.
be making business decisions? Should they
Right.
be involved in the day-to-day operations of the business? And this can be quite a big problem when you have a successful business with lots and lots of employees, and all of a sudden there's a major life event, like somebody dies, and now their spouse or their family member is the majority shareholder. Should they be making business decisions at a micro level? And I think
Right.
shareholder agreements can do a great job of that. They just say simple things like, you know, if somebody wants out, who gets to buy their shares? We
Mhm.
call this first right of refusal. So if I don't want to be an owner anymore, the other owners have the first opportunity to buy out my shares before I go to the open market and say, hey, does anybody want to
Right.
be an owner of my business? And
Ah.
that type of rule can certainly come into play in succession, and I think
Mhm.
there is language you can put in these documents that provides for a peaceful transfer of power.
Yes. Right.
But most importantly, that allows the corporation to continue to make decisions in its best interest, even when the owners are changing. To go along with that, I think the real answer to any of those problems that arise with a change of ownership is a shareholder agreement. I would say that the best way to describe this is kind of like a prenup. It's
Yes.
we acknowledge that there are these corporate documents, but we have two owners with two separate identities that they want to do things together. They need to detail out what their intent is.
I have many instances of very sudden circumstances occurring that have without a shareholder agreement in place. And it wreaks havoc on the business because there is no coordination of activities or priorities that will focus on the business. It suddenly becomes a tug of war between the individual shareholders that are affected by whatever the life event may be. And again, in highly emotional circumstances, such as the death of a partner, your business partner has died suddenly and their spouse has lost a spouse. That's a huge deal. And so that is not the best context for negotiating calmly for the benefit of both parties, right? So I've seen some train wrecks in connection with the succession problem. But I have to admit, I have not seen shareholder agreements at work, which is probably a testament to how good they are because they don't have to come to an ERISA attorney to duke it out.
One of the unfortunate things is we are trying to get clients to use shareholder agreements a lot, but don't have a lot of positive examples. Most of the examples and the stuff we come across again is people that have set up a corporation and then they didn't take that second step, or
Right.
a lot of times when they bring on a shareholder, it's after the fact, after we've done all the work that we need to. They go out and bring on a business partner, and they don't they don't ask us for any help there. But I can think of a few examples. One is that after the death of a family member, a large distributor in the northeast, let's say, in Connecticut, they used their shareholder agreement to open up that first right of refusal of ownership. So it did pass to a successor, but before that individual took control of the company, I would say control, like before they had to make any business decisions, they used their shareholder agreement to open up the sale of ownership to employees within the business. And the main officer, the president of the company, said, "I would like to buy the business." Not only did he do that, but then he went and used his retirement dollars in the 401k plan by the business. So we used a Rob's transaction to solve this issue of succession. Whereas, in short, hey, the owner has died. His son doesn't want to be involved in the operations of the business. We have clear instructions through the shareholder agreement that we can sell the shares in this manner. Is there anyone that fits that bill? Great. How are you going to pay for it? With the funds in the 401k plan. So, I think shareholder agreements can do a great job of putting the power back on the people that are already operating the business, their hands, as opposed to immediately transferring everything over to the successor.
Imagine being the heir of stock who inherits this stock in an operating company, and just thinking, I don't know how to run a company. How do I make money here? The value of the company could immediately get affected by that lack of leadership at the top, and suddenly your stock is worth less and less in this company that you wish you didn't have to run. If the Rob's owner dies and the business continues on, because, for example, as with many Rob's companies, the Rob's owner may have a partner, right? So there's two human beings working in this company. If one of them dies, especially in a startup phase, the company is quite vulnerable to the loss of that key person's efforts and intellect in the company. They often have contributed a great deal to the company and are required for the company to be successful. Now that person is gone, and the surviving partner inside the corporation is facing two issues. One is the loss of value due to this key person not being there anymore. And the other is the surviving spouse is highly likely to just want to liquidate their decedent spouse's investment in the company as soon as they can and get on with their lives. They might, now that their person is gone, they might have no desire to interact with this company on any long-term basis. And they certainly don't care to be a passive shareholder, I have found. They prefer to be liquidated. And that can be extremely disruptive to the functioning of the corporation for the surviving partner. But as an appraiser, I guess I just want to hear what your thoughts are about that.
Well, if a key man is lost, in my opinion, that increases risk for the company, even if the surviving spouse continues on. And so I take care of those sorts of things in the discount rate.
Ah, the discount rate on the appraisal. Okay.
Yeah, now that reflects on the forecast, of course.
Okay.
And the forecast should also take that into consideration. If one is being forthcoming about that, I guess that it should. But if I determine that it's not, then that just means that discount rate goes up higher. And there's an inverse relationship with the discount rate and the value, because the higher the discount rate, the higher the risk, therefore the lower the value. So I look at it from that standpoint. It's a bit subjective, to say the least. It's another one. There's a million decisions you make in business valuation, and that's just one more under those particular circumstances.
Alongside the possibility of the sudden death of a key person is also their disability, to the extent to the point that they couldn't work anymore. And I guess it's a similar situation would be termination of employment of a key person. You know, the Rob's owners are employees of the company, and they may agree that, or two or more Rob's owners in the same company may determine down the road that they don't like working together anymore. They used to be best buddies perhaps, and they realize that for one of them, maybe it's not, the business isn't for them. They're not, the other person isn't ready to sell or disband, sort of reverse the whole thing. They want to keep going. And there's a dispute between these former buddies, for example. And often it's not a nasty dispute. I've gotten involved in that kind of thing, but I've also seen a lot of amicable breakups of business partnerships that, started out without any notion of considering a dissolution of the partnership in that regard. And so they don't have a shareholder agreement. It's all a sort of a handshake deal between the partners, and then they decide to part ways. And I compare that to the death or disability scenario, because sooner or later, and often quite suddenly, the business is doing without one of the key people that was originally helping it grow, and putting in a lot of underpaid, for example, equity, if you will, underpaid efforts to grow value. And so the company's doing without that person. So I think that the disputes between owners can result in a termination of employment, where again, the former employee isn't required usually to get out of, to take their stock away or to liquidate the stock. It depends on some factors there, but the company's doing without them. And so that can impact value too, I imagine. The other thing I wanted to talk about was a divorce. When partners, when a married Rob's owner divorces, whether or not they're in a multiple owner scenario or not, the Rob stock will likely be on the table in a divorce, unless there's a prenuptial agreement or a postnuptial agreement describing what would happen with it. Let's talk about your views of things that can happen to affect that will affect the value of the company. Whether usually unexpected things. I'm thinking about the death of a partner in the company, death of a co-owner, a worldwide pandemic. divorce, things like
Yes.
that, things that may come upon people rather unexpectedly. And what can that do to the value of the company as you see it?
I mean, it depends, right? I mean, it just depends on what that person was doing. There
Right.
are a bunch of rollover businesses where the person has put the business in place, has their child running the business. They have a role, but it is
Mhm.
not, it's,
They're not a key person anymore.
they're not a key person. I mean,
Right.
when it's a key person, it can be devastating. I valued a business not for Rob's uh, a number of months ago where the mother had passed and she was the majority owner, but
Uh-huh.
her kids were, running the business and everything was
Oh,
fine. But the problem was that you could see in the financials when she got sick because everyone in the business, she was the matriarch and everyone in the business was or all of the family was dealing with her sickness, and revenues fell. And then
sure.
the other
Yeah.
thing in that case is that um the company uh was a woman-owned business, and it
Hmm.
was a uh minority-owned business. And yes, it's still a minority-owned business, but now they have to figure out how the shares of the business are going to play out so that they can continue to be a woman-owned
Right. To be
business. And
certified as a
right,
woman-owned business
right.
for contracts and things.
The pandemic was terrible for the people who, I there was a business that I did where what they did was set up they were essentially a travel agent. They were a very large travel
Oh.
agent dealing with pharmaceutical businesses and trials and things like that. And
Ah,
and their business went, it just went
it
nothing.
flatlined.
Yeah, just
Yeah.
flatlined.
Yeah.
On the other hand, there was, every single um, fried chicken restaurant, every single chicken tender.
The comfort food franchises.
Yeah, they went through the roof.
Yeah.
And then the interesting thing right now is, and because of pandemic related assistance, a lot of businesses ended up with a huge amount of cash that,
Right.
so that's something that affects Rob's businesses very strongly.